Over the next few minutes, I want to talk to you about securities derivative and class actions filed against DNOs in Israel. Now, along with liquidators' claim, those are in fact the most risky claims when they come to the claim amounts, the settlement amounts, and the legal expenses. Now, there are certain similarities between those two types of claims. First of all, the process itself. In both cases, plaintiffs approach the court, file motions requesting to certify the filing of either a derivative action or a class action. Chief affidavits are filed, expert opinions are filed, cross-examinations are held, summations are filed, and at the end of this, what we call mini-trial, the court decides whether or not to certify the filing of either a derivative or a class action. Now, if a claim is certified, then it will be discussed as a regular civil claim. Usually, at that stage, the parties convene and decide that they want to settle the claim and not reach a final judgment. Now, but there are differences between those two types of claim. When we're talking about derivative actions, we're talking about a cause of action of the company. Plaintiffs approach the court and they want to exercise the cause of action of the company. If compensation is awarded, it will be paid to the company's coffers and not to the plaintiffs. Whereas when we're dealing with class action, the cause of action is a direct cause of action of plaintiffs against the defendants. And if compensation is awarded, it will be paid to the class members. Now, the class actions are governed by a specific law enacted in 2006 dealing only with class actions, whereas derivative actions are governed by the general Israeli corporate law, and there's no specific law governing those types of claims. Now, over the past few years, we have seen an increase in the number of both motions filed to court requesting to certify the filing of derivative actions and class actions, and an increase in the numbers of motions certified as such. If we're taking derivative actions, for example, between 2000 and 2009, approximately 100 motions were filed to court. But during a much shorter period, just between 2010 and 2014, over 110 motions were filed to court. In 2014 alone, approximately 50% of the motions were certified as derivative actions. Moving to class actions, as you can see in the graph behind me, in 2015, there was a substantial increase in the number of motions filed to court. And in 2015, over 30% of the motions were certified as class actions. So we see there's an increase, but the question is why the increase? So one major effect was the establishment of the financial court in Tel Aviv. 3 judges presiding, specializing in financial affairs. They certify the filing of those actions and they discuss them to the merits. They have specialties in those types of claim. Also in the Central District Court in Lod, no specific financial court, but there are judges specializing in those types of claims. Now, when we're talking about derivative actions, there are 2 more reasons. One was an amendment to the Israeli corporate law a few years ago, and because of that, not only shareholders of a company may file derivative actions, but also bondholders and directors of the company may file such claims. So more plaintiffs, more potential claims. Another reason is the process of disclosure of documents. Let's say, for example, you're a minority shareholder. You want to exercise a cause of action of the company, but you don't have the information. You don't have the documents. You can approach the court, request the court approval to disclose certain documents. If you're granted disclosure of documents, then you have enough information to substantiate your claim to court. Moving to class actions, one major effect was that Israeli Securities Authority in the past few years started to finance proceedings. Moving back to this minority shareholder, you want to file a claim, a class action against a certain company, a corporation with endless resources. Sometimes it may deter you, but if the Israeli Securities Authority will assist you, will finance this proceeding, obviously it's easier to pursue such a claim. So we've seen there's an increase, and we've talked about the reasons for the increase. Let's talk about the types of motions filed. Now, if we're talking about derivative actions, we've identified 4 main types of motions filed to court. First of all, motions filed pursuant to what plaintiffs contend was an unlawful distribution of dividends. If a company wants to distribute dividends to the shareholders, it must comply with certain tests. It must show, for example, that it has enough profits from which it can distribute dividends. It has to show that it will be solvent even after the distribution of those dividends. Failure to meet either one of those tests, or maybe both of them, may lead to a derivative action. Another type are what we call, or the classical type, are just failed transactions. The claimant will approach the court saying that the company entered into a failed transaction, fraudulent transaction, disastrous transaction, which caused losses to the company. And the allegation will be that the D's and O's should not have approved this specific transaction, or that they negligently approved this failed transaction, and as a result, the company sustained losses. Another type are claims filed pursuant to remunerations paid to senior office holders. The allegation will be that the D's and O's did not follow a certain process of approval, and hence substantial amounts of remunerations were paid to senior office holders in the company. Finally, we have claims filed pursuant to fines or sanctions imposed upon a company, and the allegation will be that the D's and O's negligence led to the imposing of those fines and sanctions. Now, if we're talking about class actions, there are three main types of claims filed, security class action claims. First of all, claims filed as a result of what plaintiffs contend was misleading details contained in the company's reports. Either it's financial reports, and maybe it's immediate reports to the stock exchange, or maybe the prospectus. It can be either misleading details or lack of material details concealed from the public. Another type are claims filed pursuant to cessation in trade in the company's shares in the stock exchange. For example, if the holdings of the publics in a specific company fall beneath a certain percentage, then the trade in the company's shares may cease. This may lead to class actions. And then we have motions alleging that the price paid in consideration for the company's shares was unfair or inadequate. It can be either in the framework of a reverse triangular merger or in the framework of a squeeze-out. I just want to make two final notes regarding class action. First of all, about a year ago, the Supreme Court handed down a judgment regarding the stage in which a defendant in a class action should file a third-party notice. Now, up until then, the defendants usually awaited for the court's decision as to whether or not to certify the filing of a class action, and only if it's certified, a third-party notice was filed. But the court determined that the stage to file a third-party notice should be already at the preliminary stage, meaning that when you file your response to the motion to certify the filing of a class action, that's when you have to petition for the court's approval to file a third-party notice. There are two main implications to this. First of all, let's say you're an insurance company, you deny coverage. You should know that you may be adjoined to the proceeding already at the early stage, this mini trial we talked about earlier. Another implication is that you have to be very decisive. Your DNOs, you're sued in a class action. You have to know who are the third parties, to identify them in the very early stage of the proceeding and request the court's approval to file a third-party notice against them. So one final note I would like to make relates to the amounts awarded in favor of the winners, okay? If, for example, we had a case that concluded a week ago, a class action motion was denied. The court did not certify the filing of a class action, and the company was awarded its out-of-pocket expenses. Now, the company was able to present invoices indicating that it paid over $250,000 just to the expert for the expert opinion. But at the end of a lengthy proceeding, two instances, including an appeal, the amounts awarded were only $30,000, which gives you a proportion regarding the amounts awarded in favor of those who win. I thank you for your attention.